দর্শক, গেল ৫ আগস্টের গণঅভ্যুত্থানের পর স্বৈরশাসক শেখ হাসিনার পলায়ন এবং তার দোসরদের বিচার প্রক্রিয়া এখন চলমান। আন্তর্জাতিক অপরাধ ট্রাইব্যুনালের জুলাই গণঅভ্যুত্থানের হত্যা, গণহত্যা এবং আওয়ামী লীগ সরকারের বিগত ১৫ বছরের শাসনামলে গুম, খুনসহ মানবতা বিরোধী অপরাধের বিচার চলমান। বাংলাদেশের আন্তর্জাতিক অপরাধ ট্রাইব্যুনালের চিফ প্রসিকিউটর মোহাম্মদ তাজুল ইসলামের বিশেষ পরামর্শক হিসেবে কাজ করছেন বিশেষজ্ঞ আইনজীবী টবি ক্যাডম্যান। তিনি লন্ডন ভিত্তিক গার্নিকা 37 ল ফার্মের যুগ্ম প্রধান। আজকের আইন অধিকারে কথা বলবো টবি ক্যাডম্যানের সাথে। আপনাদের সঙ্গে আছি আমি ব্যারিস্টার মোহাম্মদ মাহফুজুর রহমান মিলন, ডেপুটি অ্যাটর্নি জেনারেল ফর বাংলাদেশ। আর আলোচনার জন্য বিশেষজ্ঞ হিসেবে উপস্থিত রয়েছেন বাংলাদেশের আন্তর্জাতিক অপরাধ ট্রাইব্যুনালের চিফ প্রসিকিউটরের বিশেষ পরামর্শক টবি ক্যাডম্যান। Very welcome, Mr. Toby Cadman. How are you?
Very well, thank you. Thank you for the invitation.
Okay. Mr. Cadman, you have extensive experience as an international criminal law specialist. You work in Bosnia, Kosovo, Rwanda, Yemen, Syria, and Ukraine on various issues. Having that kind of knowledge and experience in post-conflict justice worldwide, how do you evaluate Bangladesh's current effort towards transitional justice and accountability?
Thank you. So I think the first thing to say is that every situation, every post-conflict situation is very different. And every situation requires a different response. What we have experienced, certainly over the last 15, 16 years in Bangladesh, is a whole host of crimes have been committed. Obviously, if we go back to July, August of last year, that was a series of incidents of catastrophic levels that require a real response, a real judicial response. I think one of the things that we have to consider is that it's not just criminal justice that needs to respond to this. Of course, we have the International Crimes Tribunal, which we can come on to, but of course you also have the Commission of Inquiry for Enforced Disappearance. You have a number of different mechanisms that are necessary to address a transitional justice response. And of course, one of the things that we have to recognize and one of the things that we have to understand, and for the public to have trust and confidence in the process, is a recognition that this is not something that can be resolved overnight. It's something that takes time. It's a continually evolving situation. And so I think what we have to recognize is that we're still in very much the early stages of addressing these issues. Since the interim government came in after August of last year, a number of steps have been taken, a number of very positive initiatives have been taken, and the recognition that the International Crimes Tribunal, as a judicial institution, as it was previously under the previous regime, was heavily criticized by the international community, was recognized as being a politically motivated process and a complete circumvention of the rule of law. And obviously the recognition that in order for the public to have trust in the process, that system had to be fundamentally reformed. And that is what we have seen. And of course, there have been significant amendments to the legal framework to how the institution operates in practice. But of course, as with any institution, no institution, as we know, whether it's a national or international tribunal, is perfect. There will always be room for improvement, and there will always be criticisms as to that process. And I think what is important is that the interim government responds positively to those criticisms and those challenges and implements the necessary reforms in order to ensure that the highest national and international standards are maintained.
So you sat with the Professor Dr. Yunus, the Chief Advisor of Bangladesh, and you urged that the interim government of Bangladesh should refer the cases of the July-August massacre to the International Criminal Court, ICC, which is situated in Hague. What is the reason behind that kind of statement?
So I would say, first of all, having had several meetings now with Professor Yunus discussing a whole range of issues that Bangladesh faces in terms of the International Crimes Tribunal, but also in relation to asset recovery, and the discussion around the International Crimes Tribunal and the International Criminal Court came up because of the difficulty that the country faces in ensuring that the most senior perpetrators are returned to Bangladesh to face trial. What I had indicated to Professor Yunus was that the option of the International Crimes Tribunal should not be discounted. Whether it is a matter of referring cases to the ICC, referring a situation to the ICC, or using the ICC to help support the domestic accountability mechanism, what I had suggested was that is something that the interim government should consider. I measure that against the need to ensure that these types of cases are best served by being tried in the country where the crimes occurred, so that the victims and witnesses have better access to them. But of course, we also have to recognize that there are certain challenges. The position now is that the cases referring to the July-August killings of the students is going forward before the International Crimes Tribunal. It may well be that there is room for discussion with the International Criminal Court in respect of other matters, in respect of the widespread enforced disappearance, extrajudicial killings, arbitrary arrest, torture, which we have seen over years in Bangladesh. And so what I would say is that the first step, because we also have to recognize that the International Criminal Court is a court of last resort. So it is only if the state is unable or unwilling to provide an accountability mechanism that matters should be sent to the International Criminal Court. And so the first point is, if they can be dealt with here, then they should be dealt with here. And certainly what we are, and when I say we, I refer to the ICT prosecution, as I'm a member of that team. What we are committed to is ensuring that cases are dealt with appropriately before a national tribunal. But of course, we also have to recognize the challenges of whether we want to talk about Sheikh Hasina or whether we want to talk about any other senior perpetrator that have managed to flee the jurisdiction. It is much better to have a trial with a person in person than in their absence.
Right.
But of course, this is very much a balancing process, and certainly the decision has been taken that as far as the July-August cases are concerned, they will be tried domestically before the International Crimes Tribunal. But of course, the interim government will have to consider whether the wider cases of crimes against humanity committed over a period of years could also be prosecuted domestically, or whether they should be sent to the ICC.
Internationally. You know that International Crime Tribunal in Bangladesh is basically constituted by the International Crime Tribunal Act 1973, and there are 26 sections in that act. And there is a lot of questions and argument, ongoing issues regarding the reform of that act. Okay, and already some of the reform already implemented recently, but amending the ICT Act is not just a legal necessity, but a moral imperative. Ensuring that the trials are fair, transparent, and beyond criticism will not only honor the memory of the victims of the July massacres, but uphold the principle of justice. So, do you think still now the reform is necessary in that act?
First of all, I would say that in order for victims to...
Or more readily, what kind of reform is necessary?
Sure. So first of all, I would say that in order for victims to have a sense of justice, the process has to meet the highest national and international standards. There has to be fair trial guarantees, because if we embark on a process where it is, as with the previous ICT, a politically motivated show trial, which is effectively what they were previously, then that serves no purpose to the victims, and it serves no purpose to the people of Bangladesh, who need to have trust in that institution. So when the process was started, a number of recommendations were made in order for certain vital elements of the legislation to be reformed, and that process has resulted in a number of important amendments to the legislation to ensure that fair trial is guaranteed. But with any institution, with any accountability mechanism, again, I go back to the comment that no system is perfect and all systems are reformed over an evolving period of time. Certainly my experience of dealing with Bosnia, with Kosovo and other situations is that the legal framework is continuously updated to ensure that the highest standards of fair trial are maintained. I have made recommendations in consultation with the Chief Prosecutor and the Law Advisor as to additional amendments that I think that are necessary, and I base those on, if we look at the criticisms that were previously made by international human rights groups like Human Rights Watch, Amnesty International, ICTJ, all of these groups had criticised. I had myself voiced criticisms of certain aspects of the legal framework that I did not feel met international standards, and so those recommendations have been made for additional amendments to be made. Now, of course, it's up to the interim government to ensure that those amendments are implemented. But I think in terms of the Act and the rules of procedure, whilst critical amendments have been made, there are still amendments that I believe should be made just to ensure that the process meets the highest standards. And
what about the prosecution team? We are seeing that the prosecution team is working very hard, but are you think that they are very competent, they are very well equipped, or resourceful, or more capacity should build up? What about your statement?
So I don't think I've ever worked for a prosecutor's office that is resourced appropriately for the job they have to do. So every prosecutor's office I've ever worked in lacks resources. What I would say is that at the ICT prosecution, you have a team of very dedicated legal professionals who recognise the responsibility of their job. They recognise that this has to be done properly, that this has to be done effectively, and it also has to be done without too much delay.
Right.
In terms of the resources they have, I think that they do lack critical resources.
Okay.
It's not a question of competence. All of the prosecutors that I've worked with are highly competent and highly dedicated to what they do. I mean, they're led by a chief prosecutor who is extremely experienced and runs the office as I would expect a chief prosecutor to run it.
Right.
He, from the outset of my engagement with him, we have had a very, very collaborative relationship. I give my advice on what I think should be done. Ultimately, it's a matter for him to decide because he's the head of the institution. But what I can say is that he, in particular, is operating under very difficult circumstances.
Right.
We know that there are continuous attempts to undermine his work. But what I can say is that he's doing an exceptional job in very difficult circumstances. Okay,
Mr. Cadman, we'll continue our conversation on some other important issues right after a short break. Please stay with us. দর্শক দেখছেন আরটিভির বিশেষ আলোচনা অনুষ্ঠান আইন অধিকার। এই পর্যায়ে নিচ্ছি বিরতি, ফিরছি একটু পরেই। সেই পর্যন্ত সঙ্গেই থাকুন। আবারও আমন্ত্রণ আরটিভির বিশেষ আলোচনা অনুষ্ঠান আইন অধিকারে। আজ কথা বলছিলাম বাংলাদেশের আন্তর্জাতিক অপরাধ ট্রাইব্যুনালের চিফ প্রসিকিউটরের বিশেষ পরামর্শক টবি ক্যাডম্যানের সাথে। Welcome again, Mr. Toby Cadman. So my next question is about the compensation claim by the victim. You know that in the July-August massacre, a lot of students and the general people killed and also a lot of students injured. So in the provision of the International Crime Tribunal Act, there is a provision of giving compensation to the victim. So what do you think? How you will assess the compensation And you know, in Bangladesh, the tort law is not well famous, or not generally it is used by the lawyers or the other team. But what do you think? How we can calculate the compensation?
It's a very difficult process, and most international tribunals have struggled with coming up with a fair compensation system for victims, because effectively what you're doing is you're putting the price on a person's life, and you have to do that with the utmost care. I think one of the ways to address that particularly is by setting up a victim trust fund in particular, so that there is a transparent process and a transparent system of appointing or designating compensation to victims. I think it would be advisable to look at the practice of some of the national and international tribunals that have dealt with war crimes cases. Obviously you can look at situations such as Bosnia and Kosovo, where they have had compensation awarded to victims. You can also look at the ICC system. The ICC has a victim trust fund, which is mandated to deal with compensation to victims more globally. So I think that there are various systems that you can look at to ensure that there is a process which is fair and transparent, but it also needs to take into account the limited resources available to the state, and that this is not a rich country, and I think that will have to be taken into account. But ordinarily what would happen is that in order to benefit from a compensation scheme, you would have to be recognized as a victim in the criminal proceedings which led to a conviction. And effectively what you are saying at the end of that is that the person who has been convicted and sentenced to whatever sentence they receive, they are the ones that have to compensate the victims, because they are the ones that have committed those crimes. So I think that from the one side, you have to look at whether those accused persons who are subsequently convicted, how you would seek to use their assets, confiscate their assets to pay for the victims, but then more generally have a victim trust fund that the state would effectively manage to deal with sort of the wider issues, I think.
Okay, so at this present moment, the section only tell about the compensation, but no narrative or no description about it. So that kind of section, or that section, I think should be reformed, right?
I think not only would that section need a discussion would have to take place as to whether that particular provision should be reformed, but whether there needs to be a separate regulation separate from the ICT Act that deals with victim compensation. I think, look,
some matters, rules or regulation or like
absolutely, absolutely. I mean, I think you will need to have, as we have at the Kosovo Specialist Chambers, for example, a separate internal regulation or rules of procedure on victim compensation. So I think that that's one of the things that will have to be considered.
Okay, right. Okay, my question is regarding extradition of Hasina. You call India for cooperation in Hasina's extradition. So my question is, how much it is possible to get back Hasina and face the trial?
Well, I think that's a question that you would need to ask the Indian government, not me. What I had said is that there is a legal basis for her to be extradited, and that India has to either stand on the side of impunity or accountability. And that's a very easy decision for the Indian government to make. As we know that extradition is partly legal and partly political. Of course, there has to be a legal basis for the extradition, but at the same time, there has to be political will for that person.
Political will.
Extradite.
And as far as I know, there is an agreement between India and Bangladesh. It is led by Hasina in Diden time. There is an agreement regarding the extradition of the offenders or criminals.
That's right, and look, the interim government had quite properly made a formal request for her extradition to the Indian authorities. They had made a request for Interpol to issue a red notice, and so So the authorities here had done what they were required to do. Regrettably, the Indian authorities to date have not acceded to that request and is still providing, despite the fact that she has now been summoned in a number of cases. Let's not forget that she's also charged now with contempt of the ICT, in addition to the July-August matters. And so she has been summoned. It's clear now that at least the contempt case will proceed in her absence. She will, of course, be represented by state-appointed counsel, but that case will proceed in her absence. It's not too late for the Indians to reevaluate this and recognise that this is a legal request and that there are conditions for her to be returned, extradited to Bangladesh and face trial, as she should, as anyone should. You know, anyone in which there is an evidential basis for bringing charges against them for the commission of international crimes should be extradited and face trial. Of course, what will have to be done is to ensure that all of the protections are in place to ensure that that person receives a fair trial to the highest national and international standards. And if she is extradited, that is the commitment that the Bangladesh authorities will have to give.
Thank you, Mr. Cadman. Thank you very much. We are truly honored that you gave your valuable time. Thank you very much.
Thank you, my pleasure.
দর্শক, আমরা কথা বলছিলাম আন্তর্জাতিক অপরাধ ট্রাইব্যুনালের প্রসিকিউশন টিমের পরামর্শক টবি ক্যাডম্যানের সাথে। আমরা আজকের এই আলোচনার মাধ্যমে বিভিন্ন বিষয় নিয়ে আমরা আলোকপাত করলাম। আন্তর্জাতিক অপরাধ ট্রাইব্যুনাল কিভাবে চলছে, কিভাবে চলা উচিত এবং আইনটি আরও পরিবর্তন ও পরিমার্জন প্রয়োজন রয়েছে কিনা সে বিষয়ে আমরা আলোকপাত করলাম। দর্শক, আজকে এই পর্যন্তই। ইনশাল্লাহ আমরা পরবর্তীতে অন্য টপিকস নিয়ে আবার ফিরে আসব। সেই পর্যন্ত ভালো থাকুন।